video conferencing, please mute your phone unless you're speaking. Please call the first regulation.
Kentucky Higher Education Assistance Authority, 11 KAR 16001 and 010.
11-16-001 is being amended to add master degree in interdisciplinary early childhood education to the definition of ECAC approved early childhood developmental credential, remove the specific exclusion of religious education from the definition of scholarship program curriculum, and update the description of the early childhood development education earned under the curriculum. 11-16-010 is being amended to eliminate the per semester enrollment cap of 9 hours, allow recipients to pursue a master's degree using scholarship funds, and increase the maximum award amount to the amount assessed as tuition and fees up to the full-time undergraduate tuition and fee rates at the highest cost participating public institution in the Commonwealth.
Thank you. Natalie Cummins, are you on?
Yes, I am. From the Office of Adult Education, I'm attending remotely.
Thank you. That is Natalie Cummins. There are no amendments. Are there any questions from members of the committee on this set of regulations? Seeing none, please call the next regulation. Thank you.
Education and Workforce Development Cabinet Council on Post-Secondary Education, 13 KAR 3010, 020, 030, 040, 050, and 060.
These regulations amend to update language to reflect that Kentucky Skills U is now part of the Education and Workforce Development Cabinet and to make minor updates. Additionally, 13 KAR 3010 amends to increase fees for the issuance of a duplicate diploma and duplicate transcript. There is an agency amendment that deletes these fee increases and returns the fees to their original amounts. 13 KAR 3030 amends to require a report documenting student hours of participation along with their pre- and post-assessment results in order to determine whether a student is making progress toward obtaining a GED diploma. The staff suggested amendments for these regulations amend to add definitions and amends various sections to comply with the drafting and formatting requirements of KRS Chapter 13A. Additionally, the staff suggested amendment for 13 KAR 3020 amends Section 1 to specify the minimum qualification requirements of instructors.
Committee will stand at ease. Would you please identify yourself for the record?
I assume that's addressed to me. I am Natalie Cummins, the GED Administrator for the Office of Adult Education.
Thank you so much. And I need to clean up one of my mistakes. I didn't see it correctly on my sheet here, Natalie. I apologize. But we had Becky Gilpatrick, I believe, and Miles Justice on the first regulation, which was the Higher Education Assistance Authority reg. So now on this set of regs, we have Natalie Cummins, GED Administrator, Office of Adult Education. Are there any questions from members? This set of regulations. Co-Chair Hale.
Thank you, Mr. Chair. I only have one question, and I normally ask these questions when I see any kind of a fee increase. I know this is looks like a very minimal fee increase here. Is there a specific reason that we went from 10 to 15 and from 25 to 30 on the first regulation that was announced?
Representative, that's a very good question, and I apologize. When that was submitted, it was done as an error originally, which is why we submitted the agency amendment to return the fees to the original fees, which have been standing for many years. So that agency amendment for 010 returns it. That is the fee that is currently in existence of $10 for a transcript and $25 for a diploma. And those are replacement documents, not originally issued documents.
So on
I do apologize for that.
On that note, I'll jump in, if you don't mind, Co-Chair Hale.
No, go right ahead, please.
We have staff amendments. Is there a motion for approval of the staff amendments? There's a
So
motion.
moved.
We have a motion and a second without objection, so ordered. We also have an agency amendment, which is what we just went over. Is there any discussion on the agency amendment? Seeing none, we have a motion. Is there a second? We have a motion and a second.
Second.
We have a motion and a second without objection, so ordered. So now before us, we have the reg with the staff amendments and agency amendment, which include the reversion back to the $10 fee and the $25 fee, sounds like. Was that all your questions?
Yes, and my apologies that I didn't actually see that on the agency amendment, ma'am. I apologize for that.
No apologies necessary. You all have to look at a lot of these.
I've got one quick question on the Kentucky Skills U.
Yes,
It's
sir.
now part of Education and Workforce, that cabinet. Where was it before?
Prior to this, we were located with the Council on Post-Secondary Education until we were moved, I believe, in 2019 to Education and Workforce Development Cabinet.
Gotcha. So it's already happened. This is just the language catching up with that, what actually happened.
Yes, Senator, I'm sorry. Yes, we are, we're trying to, as you say, catch up. And of course, with other changes, I'm sure there will be other catching up to come.
Okay. Any other questions? Seeing none, please call the next regulation. Thank you.
Thank you.
Education Professional Standards Board, 16 KAR 2040, 2050, and 16 KAR 4020.
162040 is being amended to update the grade point average required for issuance of the certificate, update the standards of preparation to the most recent versions, and remove portions of the regulations that are now contained in other regulations. 162050 is being amended to remove references to certification deadlines and an application form that are no longer applicable. Update the required years of experience for issuance of the speech-language pathology assistant certificate and expand upon the renewal requirements for the certificates for teachers of exceptional children and communications disorders. 164020 is being amended to remove references to special education certificates that are no longer issued, update the assignment of special education personnel to align with current special education certificates, remove portions of the regulation that are now contained in other regulations, and update the procedure for requesting a waiver of the assignment of teachers of exceptional students. The staff suggested amendments to these regulations make changes to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself for the record?
Good afternoon, Cassie Trueblood, Counsel for the Education Professional Standards Board.
There are staff amendments. Is there a motion for approval of staff amendments? We have a motion. Do we have a second?
Second.
We have a motion and a second without objection. It is so ordered. Any question on this set of regulations? Seeing none, please call the next regulation. Thank you.
Secretary of State, Department of State, 30 KAR 3010, 020, and 030.
33010 amends the application requirements for registration of trademarks and service marks to update material incorporated by reference and make a technical correction. The staff suggested amendment amends sections 1 through 6 to comply with KRS Chapter 13A, amends sections 1 and 2 for consistency with the application form, and amends section 6 to revise material incorporated by reference. 33020 amends the process to apply for renewal of registration of trademarks and service marks to update material incorporated by reference and make a technical correction. The staff suggested amendment amends section 1 to comply with KRS Chapter 13A and amends section 2 to revise material incorporated by reference. 33030 amends the system to classify goods and services for registration for trademarks and service marks to make technical and clarifying corrections commensurate with the federal program.
Thank you. Would you please identify yourself for the record?
I'm Michael Wilson. I'm the Business Director for the Secretary of State and Deputy General Counsel. And I'm joined with Jonna Ballinger. She's our Section Supervisor over Business Records.
If you would turn on your microphone, thank you very much.
Sometimes you have to pull it closer too. So, are there staff amendments? There are staff amendments. Is there a motion for approval of staff amendments? We have a motion and a second. Without objection, is so ordered. Does anyone on the committee have any questions as it pertains to this set of regulations? Seeing none, please call the next regulation. Thank you.
Under Office of the Secretary of State, 30 KAR 6011.
This regulation establishes procedures for the Address Confidentiality Program. The staff suggested amendment amends various sections to comply with 13A drafting requirements.
Would you please identify yourself for the record? Thank you. There is a staff amendment. Is there a motion for approval of the staff amendment? Motion and a second. Without objection, it is so ordered. Do we have any questions on this set of regs? Seeing none, please call the next regulation. Thank you.
State Board of Elections, 31 KAR 3010, 31 KAR 4195 emergency, 4200 emergency, and 5025 emergency.
313010 amends to establish circumstances where distribution. The agency amendment amends Section 7 and the material incorporated by reference to update statutory and regulatory references, to delete outdated and unnecessary fields, and comply with the drafting requirements of 13A. 314195E establishes the form used by a county board of elections to petition for consolidation of precincts and precinct officers. 314200E establishes the form used to document the chain of custody of records during an election contest. 315025E establishes ballot standards and procedures for election security. There are no staff amendments for these last three emergency regs.
Would you please identify yourself for the record?
Good afternoon. I'm Taylor Brown, General Counsel for the State Board of Elections.
Thank you. There is an agency amendment. Is there any discussion on the agency amendment? Seeing none, is there a motion?
Motion.
There was a motion and a second. Without objection, is so ordered. So we have before us the various KRs with the agency amendment included. Any questions? I have a question, but Senator Alvarado.
Thank you very much. Just whenever I see emergency regulations, that's always something that raises my flags. Why are these emergency regs?
These were emergency regs, Senator, following the passage last year of House Bill 574. We needed to move to have these in place just in case we had a special election. We had three, so that's why they were emergency, to get those in place in case we needed them.
Thank you. Co-Chair Hale.
Thank you, Mr. Chair. And actually, Senator Alvarado actually asked the question that I had, and I was actually going to follow up with one more. But on the first reg there, the summary of that speaks to the distribution of these records or these outside of the United States. Does that happen? Are there requests for that quite frequently?
I wouldn't say frequently, Representative. We've had one or two a year. Usually it's for research purposes. I'm off the top of my head, I can remember the University of Stockholm. That's one. Like I say, once or twice a year.
And so again, I'm reading this. I'm assuming that it's probably just for the to sell those to other individuals or to sell those to other candidates or whomever.
Correct. What we're trying to do with this amendment is kind of tighten the security of the data. There are organizations that would purchase the data from us and then try to resell it. At that point, we've kind of lost control of who's accessing it. So this is trying to tighten that up.
Okay. Thank you very much.
Sure.
Thank you, Mr. Chair.
You're welcome. Obviously, this is a hot button issue over the past few years, as you're well aware, I'm sure. But on dealing with chain of custody for records, could you go through that just a little bit on, the citizenry, the people out there, they want to know that our elections are secure. And so could you briefly go through how this regulation maybe enhances that security with the chain of custody?
Sure. So it's just trying to document every single step. Like you said, this is a hot button issue. It's, and I hate to repeat what you just said, but this is to actually instill confidence in the citizenry that every step is accounted for. There's no time that's unaccounted for. That any time after a voter casts their ballot, they can be guaranteed that there's no monkey business going.
So my question is, how does that actually work? Like boots on the ground, how does that take place under this?
So I will say this too. There were, I won't say significant in amount, but significant in substance suggestions towards this. So we do plan on refiling it probably next month. But as it stands right now, the county boards of election, the sheriffs, they're all involved in documenting any time that a machine, an election machine after election day, every single step, every process that is undertaken is documented, where there should be an accounting of every single second, every single minute of that machine from the polling place until it is brought here for the election contest.
Okay. Gotcha. All right. Any other questions? Seeing none, please call the next regulation. Thank you.
Personnel Cabinet, 101 KAR 2, 210 Emergency and Ordinary.
101 to 210 an emergency. Updates to the 2022 health insurance plan year. The emergency administrative regulation and the ordinary differ intentionally regarding plan dates.
Would you please identify yourself for the record?
Yes, sir. Chris Chamness, staff attorney for the Personnel Cabinet.
We have no amendments. Is there any discussion on this regulation? Seeing none, please call the next regulation. Thank you.
Under Boards and Commissions, Board of Pharmacy, 201 KAR 2030, 074, and 412 Emergency.
201 KR 2030 amends to revise and add requirements for the preliminary application for transfer of a pharmacist license and update material incorporated by reference. 201 KR 2074 amends to delete other organized healthcare facilities, add within the same institution to the definitions, add compounding requirements to the drug distribution section, add the requirement for the pharmacist in charge to maintain a current list of all locations where automated pharmacy systems are located and to provide that list to the board upon request, add additional requirements for medications stocked in the automated pharmacy system and for repackaging medications, and add board inspector authorizations. 201 KR 2412E is a new emergency administrative regulation that provides pharmacists, pharmacist interns, and pharmacist technicians with an authorization to order and administer vaccinations to children 3 years of age and older, and sets forth specific requirements that pharmacists, pharmacist interns, and pharmacist technicians are required to complete before administering vaccinations. The staff amendments for 201 KR 2030 and 074 amend various sections for clarity and to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Larry Hadley, Executive Director, Board of Pharmacy.
And Eden Davis, General Counsel for the Board of Pharmacy.
There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion. Do we have a second?
Second.
We have a motion and a second without objection. It is so ordered. Do we have any questions on this set of regulations? Senator Alvarado.
Thank you,
I
Mr.
couldn't
Chairman.
imagine that you would have a question.
Yes, just really briefly. When I see the age of 3 and up, I'm a pediatrician, so obviously that raises always a concern for me. Are these vaccines, the comment was being made that it can be ordered or administered, both. Are these being done under standard protocols for ages 3 and up? If there's a complication for a child of that age, is there any protocol in place as to what happens if that's administered and there's a complication? Who's contacted about that?
Senator Alvarado, this section is actually congruent with federal law, and it preempts state law. And so the only reason that we have drafted a state regulation on this issue to comply with the PrEP Act was because of a training requirement specific to pharmacists. And so The portion that you are seeing regarding 3 and up, we are required to implement within the state of Kentucky per federal regulation under the PrEP Act. Now, in terms of your question of protocol, so there is part of what is included under the PrEP Act is immunity from liability for administration of the COVID-19 vaccination. And let me just to be clear that this emergency regulation is limited for that age group, 3 through 8, which prior had not been allowed and has been extended under that federal rule, is only for the COVID-19 vaccination and only if there is an emergency use authorization or FDA approval for that age group.
And that's great. Appreciate that. The concern is there's a complication of any type. So let's say, any vaccine can be administered. People can have a reaction, or it can be Arthur's reactions. Lots of different things that can cause it. Delayed hypersensitivity reactions of any vaccine that we administer. So are there? I'm just asking if there's protocols in place from our own board that if someone does have that, is there something in place? What's the typical response, or what's recommended for our pharmacists to do if somebody does have that?
So under the federal regulation, pharmacists are allowed to administer, for instance, an EpiPen if that's what's needed, if there is an adverse reaction. In terms of regulatory provisions, we don't have anything laid out in the specific regulation other than what is implied from the federal rule. But Mr. Hadley might be able to speak specifically to, in practice, what it looks like for those pharmacists that might be encountering these types of adverse reactions to vaccinations.
Thank you, Eden. Senator Alvarado, the pharmacists who are administering have the ability and the authority to administer or react to an adverse reaction, an anaphylactic or reaction to the actual vaccine. With, as Eden said, EpiPen, for example.
Okay. I mean, there's other reactions besides anaphylactic, though, right? There's lots of different reactions that can happen to anything that gets injected, and again, there's, I think, 4 different types of hypersensitivity reactions. Anaphylactic is the first of those 4, but there's several different types. So that's what I'm wondering is, are there protocols required for our pharmacists to follow if people have those? Child comes in, gets a vaccine, things look good for the first 30 minutes, there's discharged home, and they have a reaction at home once they get there. Is there a protocol? They'll call the pharmacy and say, hey, my child got this, they've got a reaction now, they're at home, they've got a complication from a vaccination potentially. What's in place for protocol for our pharmacists who are now administering those? Is there something in place? Because not everything is anaphylactic. It requires Benadryl or a steroid or a EpiPen or epinephrine that's done on site. That's if you're there. So if someone comes in, gets a vaccine, 3 p.m, they go home, they call you back, 9 o'clock, now that child's having a problem. Is there a protocol in place for our pharmacists to manage that?
At this time, the 4 different types of reactions are not, there are not protocols for each specific one. That's certainly something that we'll take a look at and codify those.
That'd be great, or at least some type of perhaps a recommendation of what should be done if those are administered there. I just know, again, what will often happen is someone will contact a pediatrician, show up to an ER after hours, and people often don't have information when things were administered. That becomes always a complication. So it might be worthwhile to at least have some requirement for a protocol in place if we're going to start doing that there. Thank you, Mr. Chairman.
Thank you. Do we have any other questions? I've got a few here. Is this emergency authority, is it limited to COVID vaccinations?
So in terms of what this regulation is specifically targeted, it only allows for 2 types of vaccinations, and they are both pursuant to what is required by the state under federal law, and that would be COVID-19 vaccinations as well as seasonal flu vaccinations to individuals 19 and over.
Okay, so this is not a blanket across the board authorization for vaccines.
No.
This is a little bit, this is not encompassed in the regulation, but this is a question that I had, and maybe hopefully other members have as well, but I know Senator Alvarado is interested in this. Do general practitioners, I'm assuming general practitioners, doctors, have full authority to do the same thing that you're asking for here. Is that correct? Do you know?
Yes, absolutely. They didn't need special authority like pharmacists, technicians, or interns did, because it was already within their scope of practice.
Okay, thank you. So in your leading up to this reg, did you all happen to find out who administers most of the vaccines in Kentucky? Do we know? Is that pharmacists and their assistants, or who does that?
So I think in our research, it really depends on age. So I think for younger children, of course, those are things that are administered within a pediatrician's office. For adults, there are a significant number of vaccinations that are being administered to adults by pharmacists and by pharmacist staff. So I don't have specific statistics for you today, but I will say the numbers are very, very high for the adult population, especially for things like the flu vaccine, shingles vaccine, pneumonia vaccine, things that are very routine.
Yeah, and the reason, and Senator Alvarado may have a comment on this, but it seems to me that most of these vaccinations are not being handled in the doctor's office. And I was just curious as to why there seems to be a push to for the general practitioners not to me, that's the safest place to administer the vaccines, in the doctor's office. And so I was just curious as to why most of them seem to be done outside the office. But that was my only question. Any other questions? Seeing none, please call the next regulation. Thank you.
Thank you.
Board of Nursing, 201 KAR 2215 and 320.
201 KR 2215 amends to clarify the separate pharmacology training requirement that applies to the three categories of APRN licensees. Add new continuing education requirements relating to implicit bias and suicide prevention, with those holding an active license on July 1, 2022, being required to satisfy the requirements within 1 year, and those licensed after July 1, 2022, being required to complete the requirements within 3 years of licensure. Add a pre-existing domestic violence continuing education requirement into the regulation. Require submission of continuing education records by a free online CE management portal. Allow requests for continuing education records to be sent to nurses by email. Shorten the response period from 30 to 10 business days if a notice of noncompliance is sent to a nurse based upon the nurse's non-response to request for records. Add a preceptor continuing education verification form and modify an existing nursing continuing education employer evaluation form. 201 KR 2320 amends to clarify how and when external examinations may be used by the program of nursing, and identifies suicide prevention and implicit bias as required curriculum for all Kentucky-based programs of pre-licensure RN and LPN education. The amended after comments version amends the definitions of external examination and remediation, and amends to change provisions relating to the use of external examinations. The staff suggested amendments to these regulations amend various sections for clarity and to comply with KRS Chapter 13A.
Please identify yourself for the record.
Yes, good afternoon. Jeff Prather, General Counsel for the Board of Nursing.
There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion and a second without objection, and is so ordered. Any questions on this set of regs? I have one question. It regards the implicit bias training. Could you just maybe define what that is and why that's going to be now required?
Well, yeah, I believe the board found that after reviewing the materials on the presentations, I don't have it with me in front of me. However, there is a difference in outcomes based upon individuals' backgrounds, their and their statuses. And so this implicit bias is to train nurses to recognize biases that all individuals may carry with them that they may not even be aware of regarding their patients in particular.
So is that like race-related biases?
Race, class, I would socioeconomic level, all.
Okay. Okay. Any questions? Seeing none, please call the next regulation. Thank you.
Thank you.
Tourism, Arts, and Heritage Cabinet, Department of Fish and Wildlife Resources, 301 KAR 6001.
3016001 amends definitions for this chapter to make technical corrections and add recreational wakeboarding. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
My name is Stephen Fields. I'm the staff attorney for the Department of Fish and Wildlife Resources.
Kind of light today on these wildlife resources regs. Wow.
Yeah, we have several more that'll be on next month.
I'll see you next month. Yeah. There's a staff amendment. Is there a motion for approval of staff amendment?
Second.
We have a motion and a second without objection. It's so ordered. Any question on this set of regs? This reg? Seeing none, please call the next regulation. Thank you.
Thank you all.
Kentucky State Fair Board, 303 KAR 1005, 10, 15, 75, 80, 90, 100, and 110.
303 KAR 1005 through 1100 amend to clarify statutory authority. Additionally, 303 KAR 1110 incorporates by reference the Kentucky State Fair Board procurement procedures. The staff suggested amendment for 303 KAR 1080 amends to specify that these requirements do not apply during the annual Kentucky State Fair, to incorporate by reference the diagram of the fairgrounds and exposition center and the activity permit application, and to make clarifications. The staff suggested amendments for 303 KAR 1005, 10, 15, 75, 90, and 100 amend various sections to comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
Carrie Bauer, General Counsel for the Kentucky State Fair Board.
There's a staff amendment. Is there a motion for approval of staff amendments? We have a motion and a second without objection. It is so ordered. Any questions from members? Seeing none, please call the next regulation. Thank you.
Justice and Public Safety Cabinet, Department of State Police, 502 KAR 12010, 14010, 20020, 31020, 40010, 47010, and 50010.
502 KAR 12010 amends to add human trafficking for commercial sexual activity to the definition of victim, add a provision requiring any professional who learns of the death of a victim with whom he or she had a professional interaction to immediately notify law enforcement if the professional believes domestic or dating violence or abuse caused, contributed, or is related to the victim's death. Add a provision requiring that if the reporting patient for a forensic evidence exam is a child, the Kentucky Medical Protocol for Child Sexual Assault or Abuse Evaluation shall be used. Add a provision requiring the examination facility to enter the KSP Sexual Assault Evidence Collection Kit information into the Sexual Assault Forensic Evidence Kit Tracking Portal. Clarify notification requirements and procedures relating to samples, add material incorporated by reference, and make minor updates. 502 KAR 14010 amends to add palm print scanners to the list of optional equipment that may be employed by the department. 502 KAR 20020 amends to make minor updates. The staff suggested amendments for 12010, 14010, and 20020 amend various sections to comply with KRS Chapter 13A.
502-31020 is being amended to update the addition dates of the by reference. 502-40010 is being amended to clarify existing language and update definitions. 502-47010 is being amended to clarify the method by which the Kentucky State Police shall notify the Energy and Environment Cabinet and the Cabinet for Health and Family Services that a property contains potentially hazardous materials resulting from the manufacture of methamphetamine. 502-50-010 is being amended to establish the procedure to request the continuance of proceeding before the trial board. The staff suggested amendments to these regulations amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself for the record?
Good afternoon. My name is Amy Barker, Assistant General Counsel appearing for the Department of Kentucky State Police.
Thank you.
Good afternoon. My name is Jeremy Triplett. I'm the Laboratory Director for the Kentucky State Police Central Lab here in Frankfort.
Thank you. We have staff amendments. Is there a motion for approval of the staff amendments? We have a motion.
Second.
We have a second. Without objection, it is so ordered. I have no questions. Does anyone else have any questions? Seeing none, please call the next regulation. Thank you.
Department of Criminal Justice Training, 503 KAR 1060, 080, 090, 100, 110, 120, 140, and 170, 503 KAR 3020, 030, and 050, 503 KAR 4010, 040, and 050, and 503 KAR 5080 and 100.
503-1060 is being amended to add and revise definitions. 503-1080 is being amended to revise the requirements for schools seeking certification, remove outdated requirements, and clarify that the Office of Kentucky Law Enforcement Council Support may carry out certain administrative functions on behalf of the Kentucky Law Enforcement Council. 503-1090 is being amended to clarify the standards and procedures for in-state and out-of-state law enforcement training facilities, clarify terminology, including revision of curriculums and stipulations on curriculum approvals, and increase the time for which forms are due prior to a council meeting. 503-100 is being amended to reflect changes in and make clarifications to the processes performed by the Kentucky Law Enforcement Council staff, require that instructor forms be filed at least 45 days before the council meeting at which they will be considered, provide for issuance of an instructor certificate only upon the initial approval of an instructor, require that instructors seeking certification renewal certify that they have been monitored by the council staff, and require that the council update its instructor directory quarterly. 503-110 is being amended to clarify that trainees must pass assessments and examinations and removes redundant physical training qualifications that are addressed in 503 KR 1140. 503-1120 is being amended to clarify that passing final examination scores are based on a percentage, clarify that requests for approval of in-service training from a non-certified school may be made less than 30 days before the course is attended but must be made before the next council meeting, clarify language concerning in-service credit for college courses, remove the requirement that verification forms be sent to the KLEFPF administrator and the trainee's employing agency because those records are electronically available. 503-1140 is being amended to clarify notice requirements and processes, eliminate obsolete forms and practices, update processes to reflect current terminology and to permit use of current technology for fingerprinting, update drug testing processes to reflect contemporary testing practices and cutoff levels, and update the reciprocity process for officers and telecommunicators. 503-1170 is being amended to remove an obsolete career development category, add new career development categories related to school resource officers, deputy sheriffs, and other law enforcement personnel, revise existing career development categories, and remove language that would limit some educational programs to those offered by the Department of Criminal Justice Training. 503-3020 is being amended to modify the penalty range for disciplinary actions and add additional prohibited material to the description of prohibited obscene materials. 503-3030 is being amended to update the language applicable to local boards of education, bring part-time officers and dispatchers into the eligible category for free tuition, housing, and meals, and eliminate confusing and redundant language. 503-3050 is being amended to combine the CJIS Academy with the non-CJIS Academy. The staff suggested amendments to these regulations amends various sections to add a statutory citation, comply with the drafting and formatting requirements of KRS Chapter 13A, and make technical changes.
503 KAR 4010, 040, and 050 were amended to allow the use of any full-size silhouette target if approved by the department and to make other minor updates. 503, 5080, and 100 were amended to update definitions and to reference the current stipend amount as set by statute. The staff suggested amends various sections to comply with 13A drafting and formatting requirements.
Would you please identify yourself for the record?
Deidre Douglas, Assistant General Counsel, Justice and Public Safety Cabinet, Department for Criminal Justice Training.
There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion. Do we have a second? We have a motion and a second. Without objection, it is so ordered. I know we have one question from Co-Chair Hale.
Thank you, Mr. Chair. Actually, I have a couple, if that's okay. I'd like to go back and start with 503 KER 001090, and it's speaking there of the standards and procedures for in-state and out-of-state law enforcement training facilities. Could you just explain to me exactly what that means quickly?
Certainly, just one moment.
And maybe I can even clarify my question a little
Sure.
bit on the. Does that mean there's same procedures followed for training facilities outside of the state as there is within the state for these individuals to get their course curriculums, or is there something there that I'm missing? Maybe I'm not understanding even how it was read, but.
My understanding is that the course curriculum approval is the same no matter what the submitting body is. We do have a subject matter expert, Melissa Beck, with us today. Ms. Beck, could you verify for me that my response to that is accurate?
We must not have no one else on.
We do not see it on here. No, we don't.
She may be having technical difficulties.
Here I am.
We can hear you. We can hear you now.
Melissa,
Yes.
since we had a staffing change, so I did not originally submit these KAR, so I would just like to verify that my response to that question was accurate, Melissa.
Yes, that is correct.
Okay. All right. Thank you. And then I have one more question on the 003050, where it says amends to combine CJIS Academy with non-CJIS Academy. Maybe I'm the only one on this committee, but I have no idea what CJIS Academy is. What is that?
It's a criminal justice information system. It's a database for criminal justice information that requires specialty training. Very, very few places do not have their dispatchers trained in that program anymore, so it seemed obsolete to have two separate academies. They're combined so that everyone is getting the specialized training now.
Okay. Thank you.
You're very welcome.
I appreciate that. That probably showed my ignorance.
Not at all.
Thank you.
I
very
had to
much.
learn that when I came here.
I appreciate that. Thank you.
I'm glad you asked it because I had the same question. Any other questions? Seeing none, please call the next regulation. Thank you.
Transportation Cabinet, Department of Highways, 603 KAR 3100, 5360, 10011 emergency, 040 emergency, and ordinary.
603 KAR 3100 establishes additional types of noxious weeds and invasive plants to be removed from rights of way by the Department of Highways. The staff suggested amendment amends Section 1 to remove redundant language and comply with the drafting requirements of KRS Chapter 13A. 603 KAR 5360 establishes procedures for the Division of Emergency Management to request the Transportation Cabinet to display missing person announcements on variable highway message signs. The staff suggested amendment amends the necessity function and conformity paragraph to correct the statutory citation and Section 2 to make technical changes. The agency amendment amends Section 2 to expand reporting requirements. 603 KAR 10011 emergency repeals 603 KAR 10002, 10010, and 10021 because they are obsolete and unnecessary. 603 KAR 10040 and 10040 emergency establish permit fees for advertising devices. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself for the record?
Sorry, Mr. Chairman. This is John Johnson, Assistant General Counsel, Office of Legal Services. I'm here with colleague Larissa Pletcha, Staff Attorney, and Ricky Sizemore and Mark McCoy, Subject Matter Experts.
Gotcha. There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion. We have a second. Without objection is so ordered. There's also an agency amendment. Is there any discussion on the agency amendment? Seeing none, is there a motion for approval of the agency amendment? Motion. Second. Without objection, it is so ordered. Do we have any questions on this set of regs from anyone on the committee? Representative Frazier.
Hi, yes, thank you. I do have a question in regards to the missing persons regulation. There was comments submitted that brought up two issues that seem to me to be very reasonable. One is in regards to who can request the posting as it's currently written. Only the local search and rescue coordinator is able to make that request. And, you know, again, with it being a 24-hour, 7-day-a-week need, is there any flexibility there for, you know, anyone else on the staff to be able to make this request?
I'd like to defer to Mr. Byrd on that if he's available. And I forgot to mention him earlier. Director Byrd.
Yes, good afternoon, committee. Yes, that has been addressed in the KAR. It now reads that the local search and rescue coordinator, EM director, Kentucky State Police, or local law enforcement can make that request to Kentucky Emergency Management. Perfect.
Thank you very much. May I have a follow-up question? Yes. Okay. There was also in Section 2, subsection 8, that the posting would be removed after 4 hours. And again, it goes back to this is a 24-hour, 7-day-a-week need. And, you know, if for example, if the need arose at night and it was placed at night, you know, after 4 hours, it has the potential to expire before anyone essentially gets to see the notification.
Yes, ma'am. There is provision in the KAR to allow for a request to be made that be extended past the 4-hour standard that's in the KAR at this time.
So that would be the person, when they make the request, they can say, we need this posted for longer than 4 hours. Is that the time that they would make that request?
I believe the way it is worded would indicate that the local community would need to request that we extend that posting past the 4 hours. It's going to be set up by Transportation Cabinet for 4 hours. So if we had not located the missing person within that window, the local community would ask to extend that past the 4-hour standard.
Okay, thank you very much.
You're welcome. Any other questions? Co-Chair Hale.
Thank you, Mr. Chair. And I want to just follow up on Representative Frazier's question there. And I still want to come back. That answer was, I don't think that answer was exactly sufficient for myself. Let's just say, for instance, that was posted at midnight. Mm-hmm. Okay, so we're only going to post that for 4 hours from midnight to 4 a.m. We're going to have a very limited amount of people probably see that. And then we're going to someone's going to have to make a request again to post that another 4 hours. I mean, is there not a immediate way to get that posted, let's say for 8 hours or something of that nature? That was just my concern. If we put that up at midnight or 11 p.m., then we're going to take it down at 3 a.m. So in a sense, that's not doing really what we're posting that to be for what we're wanting to be accomplished by that, in my opinion. Is there a response from anyone on that?
Yes. Mr. Byrd, do you have another way to address that question? Or maybe Jeremy Brown, do you have a way of answering that question?
Yeah, I think I'd rather defer to the Transportation Cabinet on that, what issues they run into if we go past 4 hours, if any.
Jeremy, do you have anything specific that you would like to indicate? Jeremy works for our cabinet and is addressing dispatch issues right now, and may or may not be able to answer the question. But essentially, the cabinet believes that there is a method of resubmitting the request in such a way that we can renew the display. We also have to consider the hierarchy of the requests that come in. So for example, during the time that the request comes in, the message is posted, there is a much more urgent request that comes through that would need to come onto the onto the board instead, that window of time tries to accommodate for that. Jeremy, are you there? It looks like maybe you are. Yes. Okay. Do you have anything to add to that?
Yes. So the boards are used for multiple messages, including traffic conditions, including crashes. The 4-hour window is kind of a historical time frame that if we haven't had any updates after 4 hours, we're worried that we would be leaving a message up for multiple hours, even if the person's been located and we haven't been notified that they have been located. So it's kind of a fail-safe to keep that message from being up there longer than it's needed to be. There's also a condition where when messages are left up for several hours at a time, people tend to ignore them. So we want to make sure that the messages up are fresh and current.
Okay, Mr. Chairman, may I continue
Please
just a
proceed.
moment? I know that Representative Frazier had worked tirelessly on a piece of legislation concerning this, basically this issue. Mr. Chairman, is it out of order to refer to to Representative Frazier at this point? May I do that?
You have permission.
Representative Frazier, is that explanation what you intended for it to be in that time period, or is that something that you think that we could? I'll ask you to go if you want to comment on that.
Thank you, Co-Chair Hare. And again, I do appreciate the work that you've put forth on this, because this will save lives, no doubt. We have an aging population and an increase of the significance of Alzheimer's and all other types of missing activities. So this will save lives. And so I guess my follow-up question would be in response to what was given is, and if you're triaging things, what is more important than a missing person? And my second point would be, again, going back to the time of the display, if it was posted at midnight, there's not going to be a fatigue of people seeing it. Essentially, no one is going to have seen it at that point. So it seems to me that the whole goal is for the public to be aware and to be on the lookout for this information. So there seems to be a method or a way that we could initially make the posting for longer than 4 hours.
Let me respond here. Robert, I don't know if you want to join in on this, but and maybe this may help answer the question. There are literally thousands of reports made on a weekly basis. If we leave them on there too long, we cannot accommodate all of the requests. And we're also only looking at an area that involves the interstates that are heavily trafficked at 24/7 and parkways. So those areas are not going to be vacant roads at nighttime. They're going to be heavily traveled. And we also have the issue as to location of the request. These issues were discussed when we drafted the regulation, because obviously there's going to be counties that are going to be more targeted than others, and we have to make the determination which county, what segment of highway that we have to do the posting. But it's my understanding that, and I didn't want to go into any details, that's why I defer to the subject matter experts. It's my understanding a very simple request would be sufficient to extend it beyond 4 hours. And it actually may need to be moved to another location in the state based upon references made in their determination of the travel, the direction the people are traveling, particularly with minors.
Follow up.
Yes.
Thank you for that. But again, I guess it would go back to, if you're going to request something longer than 4 hours, then it has to be done at the expiration of 4 hours, that there's no way to initially post it 4 hours. And again, if it's 11 o'clock, midnight, then you've got someone having to contact your agency again at 3 or 4 a.m. in the morning. That just doesn't seem efficient.
Do either of our subject matter experts have an estimate of how many devices we have in place at this time? I would like for the committee to know the number of devices that we're actually dealing with. Anybody still there? Is he gone?
I'm here.
Okay. How many devices?
DMS signs on interstates and parkways are looking at less than 40. And that's statewide coverage. Also, to clarify too, when we put the messages up, these messages will go up on every DMS board on all the interstates and parkways instead of just in the regional area.
Thank you. Thank you. That would have been a good question. Yes, thank you.
Would you like to proceed, Representative?
I have no further questions.
Okay. Any other questions on this regulation or any of the other regulations before us? Any questions on billboards? I can't believe we did not have a question on billboards. Seeing none, please call the next regulation. Thank you.
Thank you.
Thank you.
Education and Workforce Development Cabinet, Board of Education, 702 KAR 7125.
This regulation was amended to provide an exception to in-person attendance for students subject to quarantine or isolation due to the COVID-19 pandemic.
Would you please identify yourself for the record?
Good afternoon. Todd Allen, General Counsel for the State Board of Education.
Matt Ross, Policy Advisor for the Office of Finance and Operations.
There are no amendments on this regulation. Do we have any questions? Senator Alvarado.
Thank you, Mr. Chairman. I noticed this was filed initially with an emergency, and that emergency has been withdrawn. I guess the question is why?
Senator Alvarado, the emergency regulation was originally filed, let me get all my dates straight here, before the extraordinary session of the General Assembly. The General Assembly took action with Senate Bill 1, I believe it was, to address the funding piece related to students who may be learning remotely during that period of time. So the emergency was no longer necessary in order to provide schools the funding that they were relying upon based on attendance counts, and for that reason we withdrew the emergency regulation. This matter has remained in place because I believe there's a data collection issue and end-of-year issue that the program area wishes to address.
This will become effective, I mean, once this regulation gets adopted, how many days from now?
I believe the tentative date would be April.
Okay. So, all right. So it'll be close to the end of school. That's why I'm wondering,
Yes, sir.
in terms of that being in effect. So the emergency was filed more or less because of a funding issue. That was the original purpose of the emergency, was more for funding for schools. So that was addressed by the special session, so that's no longer the requirement. That can be regular. That's what I wanted to make sure I understood if there was an emergency that suddenly went away or not. It was more related to funding.
That's right. That's right.
To clarify, I think it was having to do with the SEEK formula. Is that correct? As far as in-person attendance, the calculation.
That's right. That's right. That's driven by average daily student attendance. Gotcha. And this was a mechanism to calculate that. And Senate Bill 1 relied upon previous year's data for funding the school.
Right.
So that no longer was an issue.
Any other questions? Seeing none, please call the next regulation. Thank you.
Thank you.
Kentucky State Police, 745 KAR 1035.
This regulation is being amended to add and delete certain sections to conform with statutory revisions. The staff suggested amendment makes changes to comply with the drafting requirements of KRS Chapter 13A.
I think we have a representative from the Kentucky State University. Yes, this is not the Kentucky State Police. Identify yourself for the record. I'm sorry.
Yes, I'm sorry. It's Lisa Lang. I'm the General Counsel for Kentucky State University.
Thank you. There's a staff amendment. Is there a motion for approval of staff amendment? Do we have a motion? We have a motion. We have a motion and a second. Without objection is so ordered. Any questions on this set of regulations? I've got a question before we start. What are we doing? The summary was very brief.
Yes, the purpose of this the amendment to the regulation is to align the regulation with the statute. The statute was changed, and when it changed the numbering. So we just needed to go in and we needed to make sure that our current regulation aligned with the changes to the statute. So substantively, there really has been no change.
So procurement procedures, has there been a change to the procurement procedures?
There's been a change to the statute that governs all universities.
Okay.
So when that statute changed, the way we wrote our regulation, it was keyed and tied to the numbering system in the statute. And so we had to go back into our regulation so that the regulation still identified the provisions that we were planning on complying with.
Okay, so I guess my main question is why, theoretically then, it would apply to all universities. Is that correct?
Our regulation doesn't apply to all universities. The statute does. I apologize for not being clear.
No, that you answered my question there. That was what was confusing me is why wasn't this through CPE or why is this just Kentucky State? Okay. Any other questions, Representative Frazier?
Hi, thank you for being here today. And I guess just in the light of the recent news, it seems to be, could you give a statement or talk about your procurement process? Because it seems to be there's a lot of things going on over there at the moment.
Unfortunately, I'm here today and prepared to speak to the regulation and what the statute and the regulations require us to do. I am not prepared to speak on anything else, but if you have a specific question, I would be happy to take it back and make sure that that question is answered.
Thank you very much.
If it makes you feel any better, Representative Frazier, Kentucky State has been in front of Appropriations and Revenue and my BR subcommittee a couple times recently, and probably will be back again soon. So, thank you.
Okay,
Any other questions? Seeing none, please call the next regulation. Thank you.
Labor Cabinet, Department of Workers Claims, 803 KAR 25305 emergency.
803-25305 emergency only establishes the procedure for resolution of claims for temporary total workers' compensation benefits pursuant to Executive Order 2020-277.
Would you please identify yourself for the record?
Robert Walker, Commissioner of the Department of Workers' Claims.
Dale Hamlin, the Assistant General Counsel of the Workers' Claims Legal Division.
Sam Flynn, General Counsel for the Labor Cabinet.
Thank you. There are no amendments to this regulation. Any questions for the gentleman before us? Senator Alvarado.
Thank you. Again, just it being an emergency, if you could explain why this is an emergency regulation.
Yes, Senator. First, we deemed it an emergency for two reasons. One, we filed it to comply with an executive order which was extended or codified during the special session in 2021. Also, we did it because if we didn't do it by an emergency, then it would take too long for us to get it in place. As you know, the legislature extended the state of emergency to January 15th. And if we didn't do this procedure right now, then obviously this process would have taken longer. We would not have had the procedure in place before the expiration of the state of emergency.
Anything further, Senator? I've got one question. This talks about exposure to COVID in the workplace. I know and I apologize, I forget the bill number, but we passed a bill dealing with liability of employers, relieving them of certain liability as it pertains to COVID exposure in the workplace. Does that take care of workers' comp liability, or is that separate?
I believe that was separate, Mr. Chairman.
So in your opinion, there's still possible work comp liability if they, it can be proven that they received COVID in the workplace. Is that true?
Yes, Mr. Chairman.
Okay. That's the only question I had. Any other questions from members? Seeing none, please call the next regulation. Thank you.
Thank you.
Thank you.
Public Protection Cabinet, Department of Alcoholic Beverage Control, 804 KAR 4 212 251 and 480.
804 KR 4 212
creates an in-state distilled spirits supplier license and a limited in-state supplier license to regulate traffic in distilled spirits by resident owners and suppliers of distilled spirits brands, defines an in-state distilled spirits supplier, and lays out what the new license authorizes, allows the licensee to advertise distilled spirits brands that the licensee is authorized to sell, includes that this license does not authorize the licensee to purchase, transport, store, or possess distilled spirits for the purposes of sale, establishes qualifications to obtain an in-state distilled spirits supplier license, requires applicants and licensees of an in-state distilled spirits supplier license to comply with 804 KR 4015 and to be considered a manufacturer, requires an in-state distilled spirits supplier licensee to register with the department all brands that it intends to sell in the Commonwealth, requires licensees to pay all applicable taxes for the sale of its products, and incorporates material by reference. 804 KR 4251 establishes the conditions for a special temporary license and incorporates the online special temporary license application form. 804 KR 4480 establishes provisions to allow the board to continue administrative proceedings against a licensee despite the licensee's surrender of their license, and include an exemption that this regulation shall not be interpreted to relate to the direct shipper licenses that is required by statute. The staff amendments for these regulations all amend various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Yes, Joshua Newton, General Counsel for ABC.
And I'm Allison Taylor, the ABC Commissioner.
Thank you. There are staff amendments. Is there a motion for approval of staff amendments? There's a motion and a second. Without objection, it is so ordered. Any questions from members? Seeing none, please call the next regulation. Thank you.
Thank you.
Thanks.
Department of Insurance, 806 KAR 5025.
806 KR 5025, the proposed amendments to the regulation define solvent scheme of arrangement, establish requirements relating to reciprocal jurisdictions, and make various technical changes, including to update material by reference. The staff amendment amends various sections for clarity and to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Good afternoon. My name is Abigail Gull. I'm the Regulations Coordinator here at the Department of Insurance, and we have Chad Thompson, our General Counsel, and Sean Orm, our Executive Advisor.
Thank you. We have a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second. Without objection, it is so ordered. Any questions from members? I won't even ask what solvent scheme of arrangement is. I'm assuming you know what that means. So
we do. we can explain. I might be here a little bit longer.
We don't need it explained. That's fine. Please call the next regulation. Thank you.
Thank you.
Thank you.
Kentucky Horse Racing Commission, 810 KAR 5030, 060, and 070.
810 5030, 060, and 070 amend requirements for standardbred racing, including claims races, to allow a horse scratched from a claiming race to be claimed for the same claiming prize at a subsequent race held within 30 days. Standardbred entries, to clarify qualifying provisions and delete requirements related to examinations by attending veterinarians, and standardbred races, to clarify that a driver striking pylons but not gaining an unfair advantage may, rather than shall, be cited for a violation.
Please identify yourself for the record.
Hello and good afternoon. My name is Jennifer Wolsing. I'm the General Counsel for the Racing Commission, and Sean Duddett, our Deputy General Counsel, is also joining us.
Thank you.
And Tim, do you want to introduce yourself?
I'm Tim Schmitz. I'm the Presiding Judge for the Kentucky Horse Racing Commission.
Thank you. We have no amendments. Are there any questions from members? Seeing none, please call the next set of regulations. Thank you.
Cabinet for Health and Family Services, Office of Telehealth Services, 900 KAR 12005, Ordinary.
900-12-005 establishes terms and provisions for telehealth, including requirements to protect confidentiality in a technological context. The amended After Comments version makes technical corrections, adds a definition for healthcare provider, and clarifies compliance requirements for telehealth providers. The emergency version was considered at the November meeting of the subcommittee. The staff suggested amendment to the ordinary only amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Kelly Rodman, Director of Legislative Regulatory Affairs for the Cabinet for Health and Family Services, and I believe I have Donna Vino on and Kim Minter on as well. Let them introduce themselves.
Hello, I'm Donna Vino. I'm sorry, Kim, go ahead.
I'm sorry. I'm Kim Minter, the Staff Assistant with Office of Health Data and Analytics.
Hi, I'm Donna Vino with the Division of Telehealth Services, and I serve as the Director.
Thank you. There's a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second. Without objection is so ordered. Any questions from members? Senator Alvarado.
Thank you, Mr. Chairman. So I'm looking at the language here from the regulation talking about establishing guidelines to contact, refer, and obtain treatment for a patient who needs emergent or higher level of care services provided by a hospital or other facility. I know there's been a lot of movement nationally to pass legislation for this. And it establishes some concerns for me from a liability angle. You know, I've heard, just to clarify for members of the committee, what will happen is someone will dial in to a provider from telehealth services. They might be in another location, and that provider may say, hey, you need to go. They might have an emergent situation that's developing there, and often tell that patient to go ahead and contact 911 to do that. And the person may not do it and may have a negative outcome. We're putting the onus now on the provider to provide that service. And my concern is the ramifications of this. And I'm just curious if you could comment on some of that. I mean, I know people will call a doctor's office and you'll hear on a recording, if this is an emergency, please call 911. So for establishing guidelines for this, to put this on now on the provider to make sure that they have to provide that or have to get that higher level of care, this is a little bit broader, I think, than what we just think of as a simple statement. I'm hoping you can comment on some of this. What's the impetus to put this into the regulation?
Donna, do you have an answer for that? Because I'm not exactly sure.
There has been some discussions on the type of protocols that should be developed for this type of a situation. In terms of using telehealth for emergency situations, it would require, I think, us making sure that we know the location of where the patient is at that time, that we have a phone number in case something happened in terms of the connection with the telehealth with video and audio, and that we might consider even asking, is there another telephone number that we could call if there was as a contact? I think you're exactly right, Senator. I think that we have to look at it not just like you're seeing an individual in person, because that person is at another location. And if it is someone that's on the line who says, well, I just might as well just do away with myself, and there's a suicidal situation, we will have their location of where they're at. We will have a telephone number, and that provider would then call 911. So we haven't worked everything out yet, but we have talked about the need for some type of guidance or some type of procedure that a provider could use to follow in those certain circumstances. But in this particular regulation, we do put this back on each of the health providers to establish that. So if you think something like that needs to be in regulatory language, then we can pursue doing that. But what our division is for is to provide guidance to those healthcare providers.
Go ahead, Senator.
Please go ahead.
I was just going to say, some of this would be us needing to work with the boards of the healthcare providers to making sure that it falls under their regulations as well. Maybe not directly under the telehealth board, since it gets very detailed when you talk about the emergency level.
Very good. Here's my concern with this. We're a horrible state when it comes to medical liability. I mean, I think we're one of the worst. Just got a report back. I think we are number 1 now, ranked in terms of medical liability. And what you're doing with this is going to be adding liability onto every provider out there. A lot of our telehealth and remote services now are being provided through sometimes delayed issues. So you might have somebody leaving a message, and by the time they have to contact that or have to answer that, I mean, you can call any hospital, you can call up anything that's medically related, and they're going to say, if this is an emergency, please call 911. That's the first thing you hear. And then they go into saying, if you want to leave a message for this or for that and all that sort of thing. Some are going to argue that's a method of telehealth because we're allowing audio visits now only as well. And if someone leaves a message on there saying, I'm going to kill myself, over how much time frame does that person have to respond to a message that's being left for them or something? This gets really messy when we start putting these kind of guidelines. I mean, traditionally we would say to a patient, hey, if I get a phone call now and someone says, I'm thinking of this, you need to go seek this care right now. But if you're going to say, no, it's up to you as a provider to spend however many hours trying to track where that person is at. If you get a phone call after hours, I've been on call many times, and I have a patient call me and say, I have a concern, I think my child is doing this, or I'm having these symptoms, and my response is, that's emergent. You need to go to the ER right now. That's what I recommend you do. This kind of language is going to say, that's not enough. You need to find out where they're at, call the police, call the ambulance for them, and do all that stuff for them. It's going to basically stifle people willing to take calls after hours, people willing to see these folks through telehealth services if you're adding liability on. And that becomes a concern because right now there's some common sense that if I advise a patient, please seek this level of care right now, and you're going to say, that's not good enough, you need to do that for the person, a lot of providers are going to stop taking calls, stop doing these kind of communications because of that liability risk, because we are in a horrible liability environment, probably the worst in the nation in this state. So I would urge you, if you're going to start establishing these, this is what raises the red flag for me, is that concern. In the interest of saying we're going to help patients out, if you're just going to put something else onto a provider, they're not going to provide this level of service in order to reduce their liabilities in this state. Just be aware of what this can do. Thank you, Mr. Chairman.
Just if I could pop in here for a second. For clarity, I think we allowed the emergency reg to move forward last month on this. Is there a reason? What's the reason for the emergency? Is there federal funding, or is there an issue there?
The reasoning for is when we established the reg in the earlier part of the year, so in the summer, we needed to make an immediate change because there were some things that needed to be in for the insurance plans that start on 1/1/2022 to be able to have already for their plan approval in the DOI. So that was the reason. DOI approves all plans earlier in the year, so by, I believe, September, and they needed those quick changes, and therefore for the plans to have, the carriers to have their plans in and submitted, they needed this immediate change so that they could have it readily available for the 2022 plan year.
So it was a way for the insurance carriers to determine their level of risk, basically.
Correct. And to be compliant for their 2022 plan year.
Okay.
Their plans, yes.
So if we and I truly, I mean this in a good way, could we defer this and maybe you work a little bit with Senator Alvarado on crafting some language?
We can defer.
Okay. So there's no federal funding, nothing in the background that's going to be at risk because we deferred a month?
Donna, I don't believe that. I believe there's no federal funding attached. Am I correct?
That's my understanding.
Okay.
Yeah.
Senator Alvarado, would you wish to ask for a deferral? Or
Sure. If they're willing to grant one, that'd be fine. Like I said, my concerns are those. I think they're legit, is we're transferring risk yet again onto providers in this state. And we're horrible about that in this state. And we're getting to the point very quickly where we're going to start losing a lot of providers. And we've got probably the top telehealth bill in the country. I can't tell you, at some of these legislative conferences I go to, people approach me and say, boy, you guys have done a phenomenal job with telemedicine, tremendous bill, real broad, it's great. People are trying to copy what we're doing. And then to put something like this in here saying, well, we're going to put it on the providers to make sure that if something goes wrong, it's going to be on you completely. It's one thing to do diagnosis and treatment. I get it. There's a liability there. But now it's about sometimes the patient's own responsibility. And to say, well, now it's going to be on the provider to make sure that person, if you don't do that for them, there's going to be a ramification for you for liability. It's taking it away from insurance companies and turning it away from patients as far as that, sometimes that responsibility, and putting yet something else onto providers. It's going to kill this. So I'll be happy to work with anyone on that, Mr. Chairman.
Thank you. I'll make the official request. Would you be willing to defer this particular regulation till next?
Yes, we will be willing to defer.
Mr. Chair.
Co-Chair Hale.
I've been informed by staff that we need to put that in the form of a motion and a second.
I would make the motion that we defer this until the next called meeting. Ralph will second. Do we hold on? Just committee will stand at ease. We do not need to take a vote. Without objection, it is so ordered. So, Senator Alvarado, you just bought yourself a job. So, if you could work with the cabinet on that and seek a solution, and I appreciate you all agreeing to that. Any other questions? Seeing none, please call the next regulation.
Department for Public Health, 902 KAR 2020, 230 emergency, 240 emergency, and 250 emergency.
902 KAR 2020 amends to incorporate an updated form for reporting multi-drug resistant organisms and to update the HIV reporting criteria. 902 KAR 230E, 240E, and 250E establish requirements for monoclonal antibody administration, COVID-19 test acquisition and distribution, and storage of COVID-19 vaccines, citing to FDA and CDC guidance. These regulations were promulgated pursuant to Senate Bill 2 of the 2021 Extraordinary Session of the General Assembly. The agency amendment for 2240E amends Section 2 to make a correction.
Would you please identify yourself for the record?
Kelly Rodman, Director of Legislative Regulatory Affairs. I believe there you go, DPH is on.
Yeah. Stephen Stack, Commissioner for Public Health.
Julie Brooks, Regulation Coordinator for the Department for Public Health.
Andrea Flincham, Manager of the Healthcare Associated Infection Prevention Program.
We have an agency amendment. Is there any discussion on the agency amendment? Seeing none, is there a motion for approval of the agency amendment? We have a motion and a second. Without objection, is so ordered. Any discussion from members on this particular set? Seeing none, please call the next regulation. Thank you.
Thank you.
Department for Medicaid Services, 907 KAR 1030 and 604, 907 KAR 10815, and 830.
907-1030 amends to include APRNs and PAs. 907-1604 amends to remove copays and cost sharing in compliance with statute. 907-10815 amends to allow an in-state hospital that qualifies as a psychiatric access hospital to receive funding under the Hospital Rate Improvement Program under certain conditions, to condition the program on federal approval and participation, and to delete an unused form. 907-10830 amends reimbursement provisions for acute care inpatient hospital services for a Medicaid recipient not enrolled with an MCO to allow hospice care providers to be considered post-acute care hospitals in certain situations, and to delete material incorporated by reference. The staff amendments for 1030 and 10815 amend various sections to comply with 13A drafting requirements.
Would you please identify yourself for the record?
Lisa Lee, Commissioner for the Kentucky Department for Medicaid Services.
Hopefully you have broad shoulders. You're on your own today. So there are staff amendments. Is there a motion for approval of the staff amendments? There's a motion and a second. Without objection, it is so ordered. Any questions on this set of regs? Seeing none, please call the next regulation. Thank you.
Department for Community-Based Services, 922 KAR 1565.
This regulation is being amended to include that fictive kin caregivers may receive the one-time placement support benefit that was previously available only to relative caregivers and make technical changes.
Would you please identify yourself for the record?
Sorry about that. Kelly Rodman, Director of Legislative Regulatory Affairs for the Cabinet for Health and Family Services.
Good afternoon. My name is Laura Beacon, and I'm the Regulation Coordinator for the department.
There are no amendments. Are there any questions from members? Seeing none, please call the next regulation. Thank you.
That concludes our agenda for this month. For our next meeting, we will...
One moment.
Oh, I'm sorry. That was my fault.
It's okay. I was pretty excited myself. If someone could describe the next regulation we have in front of us.
It's 922 KAR 2090 under the Department of Community-Based Services.
922 KAR 2090. This regulation establishes licensure standards for a child care center and describes the informal dispute resolution process.
Thank you. Would you please identify yourself for the record?
Kelly Rodman, Director, Legislative Regulatory Affairs, Cabinet for Health and Family Services.
Hi, Laura Beacon, Regulation Coordinator for the Department for Community-Based Services.
Anyone else for in this situation?
Laura, I think you're on mute. Are you there? Oh, okay.
I'm here. I have a few other people on the call, depending on the nature of questions asked. But as the Regulation Coordinator, I'll do my best to field all questions.
That's fine. And we have several people signed up to speak against. And for members of the committee and representatives of the cabinet that are here today, you can blame me 100% for this being on the docket. And the reason that I look at this personally as an information gathering exercise right now. I, along with other members, have been getting some complaints from the industry, and rather than letting that go on, I thought let's just go ahead and cover this before we get into session so we can see what's going on. So what I would like to do, I'm going to go ahead and skip ahead if the cabinet doesn't mind. I'm going to let the people who are here to speak against go ahead and speak, and then we'll let the cabinet come in secondly and discuss. So do we have Melanie Barker on? Do we have anyone on that's speaking against?
Hi, Senator. This is Karen Sullivan. I'm the office manager.
Can you hear me?
Yes, we have Karen Sullivan.
No. Yes, can Karen go first because she's got an appointment, so I'll just mute myself.
Who are you?
I'm Melanie.
Melanie, okay, gotcha. All right, we have Karen.
Yes, okay,
I've got a list of Robin Billingsley, Dana Bixler, Karen Sullivan, Melanie Barker. Mrs. Sullivan?
Yes, and Robin can't be on it. She's got something else that she's got to do now. So
okay.
That's okay. We'll let Karen go on. Okay, thanks.
Mrs. Sullivan, you can proceed.
Thank you so much. I appreciate you allowing us to speak on behalf of ourselves, our staff, and others affected by this issue. I had contacted ECE TRIS on Thursday, November 11th, about the certification that I had uploaded onto their site because it still said submitted but unverified. So I asked them to check, see if it was something I had done wrong or whatnot. The response I received that day said, quote, "That just means we've not had the chance to review and verify your certification. We're taking a little longer with those certifications due to the high volume of requests we're receiving." Later that day, I received another email that stated the BLS course you completed does not include first aid, which is required to meet the certification requirement on CPR and first aid. A letter from the instructor does not satisfy documentation because it is not reflected on the card from the American Heart Association. They went on to tell me what was on their website that BLS covers and told me that the description on the website does not include first aid. Neither does the certification card you submitted to TRIS. If a trainer who's also a certified instructor added this to the course to include first aid, the additional content needed to be approved through TRIS 30 days prior. We cannot accept a letter after the fact. So they basically told me that I wasn't going to meet qualifications for certification. The letter, I wanted to speak regarding the letter TRIS referred to in their email. When we took the course, our CPR trainer, Vicki Basham, included a letter for us to have along with our certificates stating what was taught in the course so that there would be no confusion. She wrote, I, Vicki Basham, teach the BLS and Heart Saver courses through the American Heart Association. With the BLS course, I provide infant, child, and adult CPR and first aid with AED. So from what she wrote, it sounds like this course meets the requirements given for CPR and first aid certification as stated in the regulation. In the regs, it doesn't say it has to be listed on the card. It doesn't say it has to be listed on the AHA website. The approved trainer made sure it was spelled out in a letter that the first aid training was included so that there would be no question about it. Unsure of what to do, I contacted Melissa Moore on Tuesday, November 16th. I let her know that Saturday, September 18th, 2021, a group of daycare employees from Little Angels Childcare attended a class along with ladies from other daycares so we could get our certification. The class, taught by Vicki Basham, included CPR and first aid. We demonstrated skills on both adult size and pediatric size dummies. When our certificates came in, I uploaded mine to ECE TRIS, where they claimed that the BLS certification wasn't good enough. I'm not sure why, since it included both CPR and first aid. I have since received an email letting me know that I have until the first of the year to recertify under another title, Heart Saver. I have taken the Heart Saver course before, and I don't recall anything being different about it, so I'm not sure why my certification isn't good enough. Please take a look into this matter for me. It was costly enough the first time we took the class. On Wednesday, December 1st, she responded, "Good afternoon. ECE TRIS makes determinations on which trainings are approved as certification. As the Director of Division of Regulated Childcare, I approved the cards for BLS to be accepted for training, including first aid associated with CPR, infant, child, and adult CPR. Due to the confusion and changes from approval by OIG to uploading and approvals of information into ECE TRIS, providers who received BLS training have been given until the beginning of 2022 to ensure adequate staff have obtained certification. Questions regarding the approvals of trainings approved for certification should be addressed to ECE TRIS. Best regards, Melissa Moore." So I guess my question is, who is in charge? Is it Melissa Moore? Is it TRIS? Because if it's Melissa Moore, she has accepted the BLS certification. Why won't TRIS? Is TRIS allowed to rule on this? This isn't the first time we've had trouble with TRIS on getting trainings approved. So many of us statewide are affected by this sudden change that I cannot comprehend even being able to recertify in the time they've provided, nor do I believe recertification to be necessary. I'm wondering if they would have even contacted me to let me know that the CPR certificate I received was rejected if I hadn't first called to find out why. How many others think they're okay because they've uploaded their certificates when in reality they haven't been approved? This is serious. Right now, the only employees that have certification at my daycare were in that class with the BLS certification. So if it's not approved, I don't know what we're going to do. Close until we get it taken care of? That is not fair to us, nor is it fair to parents. I would like to request that our BLS certification is approved for the 2 years that it's active. And if you deem it's not the proper certification, now that we're aware there's an issue, we can recertify for another program when ours expires. It's not fair to change things without telling anyone and then expect us to scramble to fix it, especially right now at such a busy time of year. Thank you for listening to my concerns. I really appreciate it.
You are welcome. Mrs. Barker, are you still on?
Yes, I'm on.
Okay. Would you like to go next?
Yes, I'll go next.
Okay.
Good afternoon. Okay. Good afternoon. My name is Melanie Barker, and I appreciate the opportunity to speak to you on behalf of Regulation 922 KAR 290, Section 338 and B and 4A and B in regards to CPR first aid certifications as it relates to Kentucky child care providers. I've owned a child care center for 19 years now, and I formed an association for child care owners and their providers in September of 2020. Back in December 2020, we had an issue in regards to CPR only with the child care provider's BLS certification. So our CPR first aid instructor, the person we use, Vicki Basham, reached out to Inspector General Adam Mather by email on Friday, December 11th. Vicki Basham said she was the instructor, or was an instructor with the American Heart Association and teaches Heart Saver and BLS with first aid. She explained that the BLS is a more in-depth class than the basic Heart Saver. Vicki Basham explains the situation regarding the BLS certification to Inspector General Adam Mather and states she certifies child care providers primarily and has never had a problem with the certifications in the past 10 years. Inspector General Adam Mather responds by email on Tuesday, December 15th, that OIG Director Melissa Moore would be reaching out to Vicki and that OIG Director Melissa Moore was the Division Director for DRCC. On Tuesday, December 15th, 2020, OIG Melissa Moore emails Vicki and says, I've shared your information with our leadership team and clarified that unless otherwise documented, the e-card includes adult, child, and infant CPR. We will adjust our surveying method to ensure appropriate credit is noted. If you notice, OIG Melissa Moore said she shared the information with our leadership team and clarified that the e-card includes adult, child, and infant CPR. So who is the leadership team that basically authorized the BLS certification? So now it is not just OIG Director Melissa Moore authorizing the BLS, it is the leadership team. So who is the leadership team? So then Vicki says, may I write a letter that specifies that the certifications include adult, child, and infant? OIG Director Melissa Moore said, yes, that would be helpful. Vicki asked OIG Director Melissa Moore if the letter would be acceptable during inspection. OIG Director Melissa Moore said yes. Vicki came up with a letter and she asked OIG Melissa Moore if the verbiage in the letter would be acceptable. OIG Director Melissa Moore said absolutely. The letter states that Vicki Basham is an instructor for the American Heart Association, and in the BLS class, she will teach CPR first aid for adult, child, and infant with AED. Again, I have all of the emails for documentation purposes. Now, remember, in December 2020, the regulation states that at least one person at a child care center has to be certified at all times during the hours of operation. Child care providers did not have to be trained, only certified. So there was not a difference in certification and training back in December 2020. So keep that in mind going forward. So I had another owner reach out to me with problems regarding her certification, which was first aid around the beginning of June 2021. OIG Director Melissa Moore tried to say she did not approve the first aid in December 2020 when I keep all of my emails, and she did approve it. So OIG Director Melissa Moore finally sent an email to this owner's inspector supervisors with Inspector General Adam Mather copied on the email stating that if this owner could provide documentation from the trainer stating first aid was provided and which of her staff attended, we will accept the letter as proof of training for purposes of licensing review. I responded and stated, this owner has the letter that you approved back in December 2020. At this time, once again, Vicki Basham came up with another letter that spelled out what she instructs in case the December 2020 letter was confusing in any way. Vicki said she teaches the BLS and Heart Saver course through the American Heart Association. She states with the BLS and Heart Saver course, she teaches infant, child, and adult CPR and first aid with AED. She ends with her name and instructor ID. I asked OIG Director Melissa Moore on Friday, June 4th, if this letter would be approved going forward. OIG Director Melissa Moore states, this documentation is approved for purposes of meeting licensing requirements for training. So why did she approve if it was not approved? Has it always been approved? Again, certification and training meant the same because in childcare, we were only required to be certified when we were never required to be trained. So on June 16, 2021, the regulation changed. It had nothing to do with the BLS certification. The change was if your staff was not certified in CPR first aid, then they all must be trained in CPR first aid. Certification means that you take a class and you have to demonstrate competency using mannequins. If you successfully complete, you receive a certification card. Training is just something to watch or listen to. It gives you an overview of CPR first aid, but you never demonstrate competency and you do not receive a certification card. So now starting on June 16th, there is a difference between certification and training. On September 28th, 2021, an owner reached out to me and asked if certifications must now be entered in TRIS, which TRIS is where they hold all of our trainings and certification records. So if an inspector comes into our center, they can get on their computer to see if we've been trained or have the, how many hours we have and that kind of thing. Since the new regulation change regarding being trained had to be now in TRIS. So I sent Angela Fultz an email with TRIS. She said certifications are to be uploaded in TRIS like the trainings. So I reached out to OIG Director Melissa Moore, and she replied on September 30th and said, surveyors will always first review TRIS for training verifications. If the certification for CPR first aid is not available, they will check the file to verify the certification is up to date. For 19 years, the certifications never had to be entered in TRIS. We only had to keep them in our files. So I said, well, you might want to contact TRIS because they told me the certifications now must be entered in their system, so they're providing us with incorrect information. So then OIG Director Melissa Moore sends me an email on October 1st and said she checked with staff and now the system is set up to receive the information. She said the system change just recently occurred. Note, I had to find it out. We were never notified, and it appears she wasn't notified either. She went on to say, due to the change in the system's ability to document this information, certification for CPR and first aid will be required to be entered in TRIS, the same as all other training. So here's where the problem started, when providers started uploading their certifications in TRIS. I had an owner reach out on October 19th, forwarded the email to me from TRIS that her BLS certification was not approved as required per Regulation 922 KAR 290, Section 11 staff requirements. There is nowhere in Regulation 922 KAR 290, Section 11 staff requirement that states the BLS certification was not approved, or at least I can't find it anywhere. On November 6th, Adam Mather emailed me saying they worked out grandfathering those who received the BLS until January 1, 2020. We did as we were told by an approved cabinet member, OIG Director Melissa Moore, and now we get penalized for it. During this time, OIG Director Melissa Moore specifically called me and told me that their choice of words were not great and that grandfathering did not mean for the life of the certification, but through the end of December. She mentioned the BLS certification had not been approved since March 2016. And I said, what? If that were the case, then why would you approve it in both December 2020 and June 2021? She had no answer. Then she stated it changed on June 16th with the regulation change. I said, no, it didn't. Then she said, well, DCC listserv sent out an email in August. I said, but it had nothing to do with BLS. And then she said, well, it was October. It had nothing to do with BLS. If she had only told us in December 2020, we wouldn't be fighting this fight right now. We shouldn't be penalized for something OIG Director Melissa Moore approved. So I did an open records check with the cabinet on Friday, November 5th. It came back on November 17th, as I knew it would. There was nothing that came back from the state DCC from September 2020 to present 11/5/21 stating the BLS certification was not approved. The letter I received from Peyton Sands in the state's legal department states, as far as I can ascertain, the DCC listserv did not send an email meeting the description in your request. My question was, I wanted the document that DCC listserv sent out saying the BLS certification was not approved for certification purposes. Just what I thought. There was none. My second question, I also wanted to know when the date the regulation changed as far as the BLS CPR first aid certification not being approved as a certification to meet child care licensing requirements. The open records check came back and said your second request pursues information rather than a specifically described document. The Kentucky Open Records Act does not force the cabinet to answer questions or provide information. As we have previously discussed, all amendments to regulation are publicly available on the website of the Legislative Research Commission. So here we are. ECE Tris, Angela Fultz, and I believe DCC Lauren Rachel tells our child care providers that the BLS certification has never been approved for certification purposes. But OIG Director Melissa Moore approves the BLS certification both in December 2020 and June 2021. Then we had a child care provider reach out to her coach on November 11th. And the coach said the BLS certification is approved and is the current directive from the cabinet. She is a coach. Then we have an inspector supervisor out of the Louisville branch, Teresa Harvey, on Thursday, January 21st, state a BLS card without an admission listed will sufficiently satisfy the regulatory requirement for pediatric and adult CPR. Then on November 18th, the coaches received an email from Stephanie Whaley, the liaison for child care wear to the Division of Child Care, with the child care wear stating that the BLS is not accepted for certification by the cabinet. So they were not notified until November 18th. Then on November 19th, Inspector General Adam Mather states, those who have had the BLS training have been given a grace period because of the regulation change. What is the change in regulation that mentions the BLS certification? I can't find any regulation changes that mentions the BLS certification. Why won't anyone answer this question for me? He also mentions there is an accommodation until January 1, 2022, and that there will be no further accommodations granted related to this matter. On Monday, November 29th, the health department person in my area sends out an email to all child care providers in our area stating, if your card says Heart Saver or Pediatric BLS, first aid on it, you are good. She is stating on November 29th that the BLS pediatric certification meets approval for licensing, and she's with the health department. There's no such thing as a BLS pediatric certification. Then this health department person states she totally feels our frustration. Frustration? She is frustrated too with this regulation change that the state took it upon themselves to make. Then she states to make sure the certification classes are face-to-face and checkoffs must be face-to-face. So how come the Child Care Council of Kentucky is not doing the certifications in this way? They are offering Zoom classes with face-to-face checkoffs, even when I have an email from the company they are using to do the certifications that Zoom trainings are not allowed. So when the company says the Zoom trainings are not allowed, the state will still allow the person to receive the certification. The Zoom trainings provided by the Child Care Council of Kentucky, the participants don't even have to show their face. So who knows if they turn on the Zoom, if they're really on the Zoom? What if they turn the Zoom meeting on and go do something else? So how do we know that these people are really being trained in order to be certified? I have screenshots. Also, she states that we must have 2 people in our building at all times that are certified. This is the health department person, which is not true. It is only 1 person. So I reach out to the state. They underline cabinet approved. Well, OIG Director Melissa Moore is cabinet approved. If she wasn't authorized to tell us that it was approved, she should never have done so back in December 2020 and June 2021. So I've emailed these questions to the state since last week regarding these issues, and they still won't respond. I was told that DCC works in partnership with the child care health consultants, health departments across the state in the best interests of Kentucky's children, right? Isn't CCHC responsible for knowing and relaying regulatory information to be able to assist child care providers? So I'm a bit confused. What does the BLS certification entail? I have that information that was submitted to Inspector General Adam Mather back in December 2020 from Vicki Basham's training agency. So I want someone to tell me why the BLS certification is invalid as a certification for child care providers. What does Heart Saver, approved by the state, teach that BLS does not teach? I've asked many times and still no one can provide an answer. On December 6th, Inspector General Adam Mather sends an email to another owner and states, the Office of Inspector General, Melissa Moore is the director in the Office of Inspector General, has no authority to decide which trainings are approved as certifications. You will need to consult with the Division of Child Care, ECE Tris, to make those determinations. My question is, when Vicki Basham reached out to Inspector General Adam Mather in December 2020, why did he have his director, Melissa Moore, reach out to Vicki Basham if his director, Melissa Moore, couldn't approve the BLS certifications, but she did approve them? If their office has no authority to decide which trainings are approved as certifications, then why does his OIG director, Melissa Moore, approve the BLS certifications both in December 2020 and again in June 2021? So she did, and we should not be penalized because she told us it was approved, and they never told us that they did not have the authority to do so. She is one of the cabinet, and we went by her word. No matter what, we would not be here if we were told back in December 2020, when the first issue came about, that the BLS certification was not approved, but was it really? Our instructor could have only certified our child care providers in HeartSaver, which the state will currently approve. But some providers wanted a more in-depth course, so they chose the BLS certification that was approved by OIG Director Melissa Moore, both in December 2020 and June 2021. Again, if OIG Director Melissa Moore was not authorized to approve, then why did she do so? I'm asking that you will grandfather all of the BLS certifications that were handed out before November 6th for the life of the certification, which is 2 years. Then, when their certification expires in 2 years, they can recertify in HeartSaver or another approved course. I think it is only fair. For example, I believe it was 2009 when the regulations changed to say we can only hire employees who had a high school diploma or GED. But if you are working before this regulation change without a high school diploma or GED, you could continue to do so because you were grandfathered in. But if you quit and then wanted to come back, well, now you fell under the new regulation and would have to have a high school diploma or GED in order to work in childcare. So I think these BLS certifications should follow the grandfathering in, like the high school and GED diplomas, et cetera.
Ms. Barker, let's take a pause here, and then let's allow the cabinet to respond. Lot of ground to cover. So whoever wishes to respond from the cabinet, please proceed.
This is Kelly Rodman, Legislative Regulatory Affairs Director for the cabinet. There's exactly that, Senator West. Thank you for bringing it to our attention. There's a lot that was just said. I knew some of this, and I think we're prepared to answer a couple of things, but this was much more detailed than I had expected. So I would request that we be able to go back and listen to the testimony again and get back to the committee on everything, because there are pieces that I have a lot of circles that are going back to a couple of things that I wasn't aware of. And yes, I knew the reg was being called, but I didn't know all the details that were going on with the reg that was being called. I will say that we did make a change earlier in the year. It is based on federal language. It does say that one person is to be certified at the facility, but let's be perfectly clear. I have 2 children that I praise my child care center every day, and they're 21 and 18 because they wouldn't have survived I had to take care of them every day. I will be honest with that. And my daughter will probably agree. But I will say that, that's one person, but with the presence of children. So that would mean you may need to have more than one person with that is certified, and it says in infant and child CPR. And then it goes up to, as age group, it moves up to the next section in the regulation for the age group. We do require what we call pediatric CPR. There is a situation where I have spoken to the American Heart Association today. We are looking into the BLS training. But the problem with the BLS training on the card is it doesn't recognize the difference between a pediatric CPR and adult CPR. And as we all would know, the pressure that you would put on a 6'2" male is going to be different than a 2-year-old. That is one of the issues that and I've called them. We will work through that. We will see if we can get them to recognize it. But when we are looking for the certification, I need to look into if all trainers are having this issue, or if it is just the one trainer that is possibly having the issue with the BLS certification. I just have to look through a few more things that we need to look into, because there are some things that I cannot discuss even on this call due to an open appeals case from the original trainer that Ms. Barker brought up.
Okay. I have a few questions. If you could hold on, Ms. Barker, I'm gonna open it up for questions first, and then we'll come back. Before I ask my questions, do we have any other questions from members on this topic? I'm the one who brought it forward, so I guess it's all me. Just from the outside looking in, as legislators, and I've got the reg here in front of me, and I've got some additional regs that go with it. But in a nutshell, it's pretty commonsensical, I guess, to think that these requirements should be fairly simple to understand what is required. And then secondly, it should be fairly simple as to what is required to meet the requirements, as far as uploading the requirements or who's in charge of receiving and reporting back. So there does appear to be, it appears to be overly complicated, I guess is what I'm trying to say. So I'm going to ask the cabinet, is that a fair statement, or am I being too simplistic?
Why don't we see there's something in the middle? I don't know if it is the most heavily regulated, there's a reason why it's the most heavily regulated industry. So I mean, is it over-regulated? No, because we're protecting children. Is it hard to understand? Possibly. Yeah. But all regulations can sometimes be hard to understand.
Right. I'm going to open it back up to Mrs. Barker for just whoever on the against side for just a moment, if you want to chime in.
Okay. Yes. I guess it was Kelly Rodman mentioned that the BLS doesn't have anything to do with adult or children and infants. Well, the BLS information that we gave Inspector General Adam Mather back in December from Vicky's training agency, it says this course teaches the following topics: high quality CPR for adults, children, and infants. So where does it not say infants and children? And if somebody is a child care center and they're watching infants up until preschool, they're only required to do the infants and children. You only have to do adult CPR when you're watching school age kids. And this covers all three. And he was given that information as Melissa Moore was in December. And if they didn't recognize that and thought there was a problem, why didn't they tell us back in December 2020 that it wasn't approved? And we wouldn't be here right now. I mean, I just can't understand why anybody would approve something, and then everybody's doing these BLS certifications, and then all of a sudden, well, I'm sorry, it's not approved, and then we're penalized for a decision that maybe it was her mistake, but we shouldn't be penalized for her mistake because we're supposed to go to them for answers, and if she gives us something incorrectly, a response that's incorrect, well, we shouldn't be penalized for that. But I just received a certification that the health department in our area did for somebody, and she actually certified them, the health department. She's a child care health consultant. She actually did this owner's certification in May with BLS. So if BLS was never approved, then she, being a health department person, should have known that she shouldn't have certified BLS. And it wasn't Vicky Basham. Her name is Jenna Phelps, and she certified them in May of 2021. Well, when all of this happened in November, that now the BLS isn't certified, instead of recertifying them in BLS, she just gave them cards that say Heart Saver so that they're approved. Is that right? Because she's already trained them in BLS, she said. So she just handed out cards that say Heart Saver to get them to pass. Is that right? And I'm looking at the cards right now. The BLS here says that it's a basic life support CPR and AED program. And the Heart Saver course said it's the American Heart Association Heart Saver First Aid CPR and AED program. It never mentions pediatric. And those are two cards. One says a Heart Saver and one says BLS. So what is the difference?
Okay. And if the cabinet could respond, we'll give the cabinet a chance to respond, then we'll try to wrap this up.
Okay.
I am going to need to, this is Kelly again. I'm going to need to, I mean, Laura, do you have anything else you would like to add? But I would like us to go back and look into this. I will say that one of the issues we do have is that a lot of what Ms. Barker has stated is based on one trainer. And at this point in time, we are in an open appeals case because we have revoked her credentials. So at this point in time, I have to be very cautious on what else we can say in this committee hearing when it comes to the actual training piece. But I have listened. I will have to go back. I will tell you, I will have to go back and listen to the full recording to get all the comments. And I will look into these things and we will see what I can come up with and report back to the committee.
Okay.
But Laura, do you have anything you would like to add?
I will just add that this issue really does go beyond the regulation and beyond my expertise. But I will say that I know the issue was that the basic life-saving training does not specifically include pediatric training. So I know that is the issue, and there is a list of approved trainings that's been accessible since 2016 that does include training. It does not have BLS on the list. It includes training, and also I'm aware that the cabinet, as stated, the cabinet gave a grace period to obtain proper certification. And I know that the Division of Child Care is using some of the federal funding received to provide cabinet approved training at no expense.
Okay. I'm going to take a pause here. Mrs. Bixler was signed up to speak again since she has not had the chance to speak yet. So if you could go ahead, Mrs. Bixler, and speak. Mrs. Bixler, are you there? We cannot hear you on this end.
Can you hear me?
We can hear you now.
Okay, great. I don't have too much more to add. Ms. Barker pretty much covered everything. One thing that I would like to add is that I have some BLS certifications within my center, and I am going to have to somehow figure out how to get them recertified if the BLS voids out at the end of December. My concern is, excuse me, I believe Laura Began said that there was going to be some free certifications. The problem is, right now, staff cannot leave facilities. All facilities are so short-staffed that we can't afford to have our staff retrained, not to mention the cost that we're going to have to pay each child care provider to be in attendance, because we have to pay them hourly as well. So we might be getting the certifications at no cost, but we still have to pay our staff to be present. With so many facilities being short-staffed, having to reduce the amount of children that they have in their facility, the funds are just very difficult to produce, and the timing is absolutely horrid. When the BLS, when I was recertified, or not recertified, when I received my annual licensing, the BLS was in my employees' binder in their files. Teresa Harvey seen it, and she never said a word about the BLS. So up until now, there wasn't a problem. It's been great doing the certifications the way that we've been managing to get our certifications taken care of. Me, I'm a 5-star facility. I require everyone within my facility to have certification. So I'm just not going to have to recertify one person. I'm going to have to make sure every one of them are recertified.
Thank you. We also have another speaker, Sandy Woodall, to testify for.
Good afternoon, Mr. Chairman. Thank you for the opportunity to speak today. I just wanted to state that looking at the regulation really looks at best practice for keeping children safe and those being able to react in a case of an emergency when caring for young children. And as a Child Care Advisory Council member of Kentucky, we were able to review this regulation and, give input, push back, and really value the best practice of looking at that pediatric, knowing, someone stated the pressure is different when you're looking at an adult versus a child. So I just really wanted to bring that to the attention of looking at best practice, making sure that the professionals have exactly what they need to keep the children safe in case of an emergency when it comes to a life, or death situation possibly. So thank you.
Thank you. Any questions?
Can I make a comment?
Yes.
Just real
Mrs.
quick, 'cause I
Rodman.
know this. This is Melanie.
Wait a second, Melanie, if you don't mind. I think Mrs. Rodman was next.
Okay, I'm sorry.
Thank you, Chair. I was just going to ask a clarifying question to Ms. Bixler, if I could.
Please proceed.
Okay.
Obviously it's a difference here in the cabinet. We have a difference between training and certification. You made and certification. And you stated that you require everyone to be certified. Does that mean everyone is certified and you don't have, because the regulation says only one person needs to be certified for each child. So, but are we getting confused? I just would need that for when I go back and look. So can you clarify, is everyone in your facility certified, or are they trained with only one person? Because the reg would mean that most everybody else would be trained, but only one person would need to be certified for the time period that a child is in the center.
Yes. Can you hear me?
Yes.
Okay. Yes. In my facility, my requirement is that everyone is certified. If for some reason I am the only one that's certified and I have to run out to, say, get my child from school, I can't leave. So in my facility, being a 5-star facility, I mandate my staff, all my staff, to have the certification, as does a lot of other facilities, because we all know one person being certified is not enough. It is not enough. Now, as far as the training, they all fall under the training because they are all certified.
Thank you. Thank you, Mr. Chair.
You're welcome. Mrs. Barker, if you could be brief.
Yes. This is all that I want to say is I have the information that states the BLS course teaches high quality CPR for adults, children, and infants. So I don't know where you're getting that the BLS does not provide that course, because I have the information here from the training center, who gets their information from the American Heart Association. So that's all I wanted to say. It does. It's just the same as Heart Saver. BLS is more in depth. Medical professionals have to take the BLS certification because it's more in depth information. That's all I wanted to say.
Okay, that's going to have to be the last word today, unless we have other questions from members. Any questions from members? Seeing none, I see this. There appears to be a lot of confusion in the industry, and a significant communication breakdown between the industry and the cabinet. And I'm not blaming anyone specifically, but it seems like, hopefully, I would ask that the cabinet try to work on this and reach out to the affected parties and come to some agreement. If I were in their shoes and I was approved, and I was approved by a trainer in that area, and then later on in the year that was pulled back, that would be very, very difficult on my business model to just suddenly have to go through some new certifications. So I would just ask that the cabinet work with these providers and try to come to some sort of solution, and then we can regroup next month, or just keep us informed as to how it's going, and we'll just go from there. Is that agreeable to the cabinet?
That's agreeable to the cabinet.
Okay. Thank you so much. That's all we have time for today. Do we have any announcements from staff?
The next meeting will occur during session. We usually move to the Monday before the second Tuesday, which would be the 10th of January at 1, although we may have to look to see how many regs we have on the agenda.
Sure. And we may have to switch due to scheduling conflicts, and like we always do. So that's okay with me. Any other business to come before the committee? Seeing none, meeting's adjourned.